He cut her off at the 40-second mark. Not a gentle redirection, not a clarifying question. Judge Harlan Speck simply began speaking, over her voice, through her sentence, and finished her legal point himself, incorrectly, then moved on as though she had already sat down. Celeste Adaora Nwanne did not sit down. She opened her burgundy leather folio to a tabbed section near the back. Her pen rested on the page, still, parallel to a column of handwritten docket numbers in the margin. Small, precise, written in the same ink she always used. She said nothing. She waited. This was a housing discrimination motion, a procedural argument about whether a wrongful eviction, executed through a ruling Speck himself had issued in chambers, had violated the tenant's right to notice under the district's established standard. It was not a complicated morning. It should not have been a difficult morning. But Speck had a way of making mornings difficult for certain people in certain ways. And the courtroom, if you had been in it long enough, understood the pattern, even if no one said so aloud. She had argued in this courtroom before. She knew the acoustics, the sight lines, the particular way the afternoon light came through the high windows and fell across the bench. She had prepared for this motion for 3 weeks. She had prepared for this judge for longer than that. When he interrupted her the second time, this time before she had finished citing the controlling precedent, she paused for exactly 1 beat and began the sentence again from the beginning, her voice level, her pace unchanged. He talked over the restart. Foster Grin sat at the opposing counsel table and did not move. He straightened his signet ring once, a small, practiced gesture, and kept his gaze on the bench. He did not look at Celeste. He had not looked at her since the hearing began. He did not need to. The third interruption came when Celeste raised an objection to Speck's characterization of the notice requirement. Speck did not acknowledge the objection. He continued speaking. When she raised it a second time, he turned, not to her, but to Grin, and asked a procedural question about the filing date of the original motion, as though Celeste had stepped out of the room for coffee and not yet returned. Desiree Okonkwo, seated at co-counsel, wrote something on her color-coded legal pad. She did not look up. Her pen kept moving. In the back row of the gallery, a law clerk, young, unremarkable in a gray suit, had a yellow legal pad across his knee. He was writing faster than the pace of the proceedings seemed to require. Nobody in the room was paying attention to him. The fourth interruption, the fifth, the sixth, this one mid-objection, the word cut in half before it could become a sentence. Celeste did not raise her voice. She did not shift her weight. She stood at the podium the way a building stands in weather, present, structural, unmoved. Each time Speck spoke over her, she waited for him to finish. Each time he finished, she continued from precisely where she had been, as though the interruption had been a brief technical delay and not a deliberate erasure. There is a particular kind of courage that does not announce itself. It does not raise its fist or its voice. It simply remains, upright, unhurried, in the room, while everything around it tries to make it smaller. The courtroom that morning was full of people who would later remember that they had been present for something. Most of them did not yet know what it was. At the 8-minute mark, Speck leaned back. "I think we've heard enough from counsel," he said. It was on the record. The court reporter's fingers were moving. Celeste did not protest. She did not sit. She stood at the podium in complete silence. 1 second, 2, 3, 4. The court reporter's keys stopped. In the back row, the law clerk in the gray suit looked up from his yellow legal pad for the first time since the hearing began. He wrote something down, then he underlined it. The folio was still open to the tab section near the back. The docket numbers in the margin were still there, written in her precise hand, the ink long since dry. She had not read from them. She had not needed to, not today. When Celeste Adaora Nwanne closed the burgundy folio, she did it quietly, with one hand, the way you close something you have already finished with. Because she never needed to open it today. If you believe the truth always surfaces, no matter how many times it gets talked over, this story was made for you. The people who keep coming back to this channel know that justice doesn't always arrive loudly. Sometimes it arrives in the transcript. Subscribe and stay close, because what Celeste does next changes everything. And it starts with a sealed envelope that was already in the mail before Speck spoke a single word. Drop a number in the comments right now. 1. If you've ever been talked over in a room where you were the most prepared person there. 2. If you've never experienced that, and consider yourself fortunate. 3 weeks before that courtroom. 3 weeks before the 9 minutes that the court reporter's fingers caught and held every interrupted sentence, every word spoken over her, every procedural slight delivered from the bench as though she were furniture in the room. 3 weeks before all of it, Celeste Adaora Nwanne was here, in this library, with a yellow legal pad, a pen, and a name she would not let disappear into a filing cabinet. The name was Eugenia Marsh. Eugenia was 74 years old. She had lived in the same apartment on the 3rd floor of a building on Meridian Street for 22 years. She had a window box with geraniums. She had a neighbor who checked on her after surgeries. She had a lease that renewed automatically under the city's tenant protection ordinance, a lease that, by every applicable procedural rule, should have kept her exactly where she was. What she did not have, after a ruling issued by Judge Harlan Speck in chambers on a Thursday afternoon, was a home. The ruling had come without a hearing, without notice to Celeste's office. Speck had accepted a procedural argument from the building's ownership group, represented by Foster Grin, that a technical filing defect in the tenant's renewal documentation voided the ordinance protection entirely. 7 paragraphs, no oral argument. Eugenia had 30 days to vacate. Celeste had read the ruling 4 times on the night it arrived, not because she didn't understand it, because she needed to understand exactly how Speck had arrived at it, which precedents he had cited, which ones he had omitted, and which ones he had authored himself in prior years that now sat quietly in the appellate record, directly contradicting the position he had just taken in chambers. She wrote the first docket number in the folio's margin at 11:52 p.m. By 2 a.m., she had 7. She was not looking for contradiction as a rhetorical tactic. She was looking for it because it was there, documented, published, part of the permanent appellate record of this district. Speck had, in 3 separate opinions over 11 years, written with considerable force about the procedural protections owed to tenants in ordinance disputes. He had, in his own language, described the kind of chamber's ruling he had just issued as an abuse of the notice requirement. His words, his name in the author line, his docket numbers. Celeste circled the 3rd passage in red and set the pen down. She did not feel satisfaction. She felt the particular clarity that comes when the shape of a thing becomes visible. Not the emotion of it, but the architecture. Desiree had come in at midnight with coffee and her color-coded outline, the kind of organized thinking that made her indispensable in preparation and devastating in cross-reference. She had been working through the argument structure in green and red. Green for what Speck would likely accept, red for what he had historically rejected. When Celeste looked up from the laptop and said, without preamble, "I need him to keep talking so the transcript fills itself," Desiree's highlighter stopped moving. She looked up. Her round face held the kind of stillness that meant she was processing something faster than it appeared. She wrote a single question mark on her legal pad. Celeste gave her the small nod. 1 motion, barely a degree of movement. Desiree recapped her highlighter. She did not ask a follow-up question. She returned to her outline and began reordering the argument structure, moving 1 section, the judicial impartiality precedents, from the middle of the brief to a tab section near the back. Somewhere it would not be reached unless the hearing went long, unless someone kept talking. At 2:40 a.m., Celeste gathered the folio, the printed opinions, and a manila envelope she had sealed before Desiree arrived. She walked to the outgoing mail slot at the back of the library, the one that went out in the morning's first collection, and she dropped the envelope in without pausing. She did not mention it. Desiree was still at the table, finishing the outline. Celeste returned, put on her coat, and tucked the folio under her arm. For just a moment, as she slid the folio closed, the return receipt label on the envelope's copy was visible in the front pocket. The address, the date, the small printed confirmation number, before the leather cover folded over it. She never said a word about it. Desiree found the opinion at 3 a.m. when she reached across the table for the folio Celeste had left open. She read the author line. She read the 3 circled passages. She turned back to the front of the opinion and checked the docket number against the column of numbers Celeste had written in the folio's margin. and found it there, third from the top, in Celeste's small, precise handwriting. Then she found the second opinion, then the third, each one authored by Speck, each one circled, each one in direct, documented tension with the ruling he had just issued in chambers against Eugenia Marsh. Desiree sat back in her chair and looked at the ceiling for a long moment. She had thought they were building a motion. She was only now understanding that Celeste had been building something far larger than a single motion. What Desiree had found in the folio the night before was not a surprise to Celeste. It was a schedule, and schedules only matter when the other party shows up on time. Speck showed up on time. He did not wait for the gallery to settle. He did not wait for the bailiff to finish the call. He was already speaking before the echo of the gavel died, granting Foster Grin's first procedural request before Celeste had drawn breath to respond, then the second, his voice carrying the casual authority of a man signing his name to something he hasn't read. Celeste rose to object. "Objection noted and overruled, counsel," Speck said, not looking up from the page in front of him. "Please keep up." The gallery behind the bar was fuller than it had been at the first hearing. 2 rows of law students, notebooks open, pens ready. A professor from the university's clinical program sat at the end of the second row, arms folded. They had come to watch a master class. They were getting one, just not the kind the syllabus had promised. Desiree did not look at the gallery. She wrote. The color-coded columns moved left to right across her legal pad. Blue for Speck statements, red for procedural rulings, green for the record citations Celeste had not yet used. The green column was still empty. Desiree kept her pen moving and did not look at the clock. It was the gallery that changed something in him. Celeste would note it later, in the margin of her folio, in her precise handwriting. Energized by observers. Speck sat straighter. His voice found a register she had not heard from him before. Something closer to performance than procedure. When Celeste cited a line of appellate authority, he cut across it without letting her finish the docket number. Inapposite on its face, he said, and he said it to the room, not to her. Counsel, I authored the standard in this district. I know what it requires. The room absorbed it. The professor in the second row uncrossed her arms. One of the law students stopped writing. The word authored sat in the air of the courtroom the way a dropped coin sits on a tile floor. Still ringing, not yet still. Celeste did not respond to it. Not yet. Grin moved first. He rose and said quietly, Your Honor, I'd ask for a brief recess. It was the first unrehearsed thing he had said all morning. The baritone was still there, but something underneath it had shifted. A tightening, the way a man's voice changes when he is doing arithmetic in his head and doesn't like the answer. Speck waved a hand without looking at him. We're moving, Mr. Grin. Desiree's pen did not move for 3 seconds. Then she wrote something in the margin of the green column. Not a citation, not a ruling. A single word, underlined once. In the gallery, a senior attorney, silver-haired, navy suit gone soft at the elbows, leaned toward the colleague beside him and said, low enough to think no one heard, She's overmatched today. The law clerk in the back row did not lean over to whisper anything to anyone. He wrote faster. He had been in this seat before. He had a reason to be here that had nothing to do with the syllabus. The morning ground forward. Speck ruled. Grin received. Celeste stood and was interrupted, stood and was overruled, stood and was talked past as though the podium were empty. Each ruling landed in Desiree's blue column with the inevitability of stones dropped into water, not random, not careless, but patterned. A pattern Celeste had been counting on. And then, in the middle of a lull between rulings, Celeste turned to the court reporter and asked, in the same unhurried voice she had used for every word that morning, whether the transcript was current and complete. Speck's 2-finger bench tap came down once, a short, dismissive sound. The reporter does her job, counsel, he said, and there was a low ripple through the gallery. Someone exhaled. The senior attorney in the soft navy suit shook his head. The court reporter nodded. Celeste held the nod for one breath. Then she reached down, opened the burgundy leather folio, and turned to the tab section she had never opened in this courtroom before. The folio was open now. Not to the argument outline, not to the case summary, to the tabbed section, the one she had touched and not read from across 3 hearings, the one whose margins held docket numbers written in her own hand before she had ever set foot in Speck's courtroom the first time. She had been waiting for this exact moment. Not the recess, not the ruling. This moment, the transcript current, the record complete, the rope already tied. Your Honor stated, Celeste said, her voice carrying without effort, unhurried as a closing argument already won, that you authored the standard in this district. I'd like to engage that record directly. No one in the gallery moved. She did not look at Speck. She looked at the page, and she began to read. Docket number, date, title. The first opinion, a 2009 appellate ruling authored by then-Circuit Judge Harlan Speck, establishing that a presiding judge's failure to allow full oral argument on a procedural motion constituted reversible error where the record showed the party was denied meaningful opportunity to be heard. Celeste quoted his language back to him verbatim, his words, his syntax, the particular construction he had used, meaningful opportunity to be heard, a phrase that now hung in the air of his own courtroom like something that had always been there, waiting to be recognized. The two-finger tap continued, slower. Docket number, date, title. The second opinion, a 2014 ruling in which Speck had written, with evident conviction, that a judge's interjection to complete or correct counsel's argument, even when the interjection was legally accurate, constituted an interference with the adversarial record if it prevented counsel from establishing their own evidentiary foundation. She read the passage in full, no commentary, no editorial, just his words, entering the transcript for the second time. The first time under his name on an appellate opinion, the second time under her voice in his own courtroom. After the second citation, the two-finger tap stopped. It did not slow to a stop. It simply stopped, mid-rhythm, as if the hand had received a message from somewhere above it and decided not to finish the motion. Docket number, date, title. The third opinion, 2018. Speck again, writing for a unanimous panel, holding that a trial court's pattern of procedural rulings that systematically disadvantaged one party, even where each individual ruling might be defensible in isolation, constituted a structural due process concern when the cumulative record demonstrated disparate treatment. Cumulative record, disparate treatment, his words, his standard, his district. Grin stood. Your Honor? The baritone was there, technically, but stripped of its rehearsed ease, the way a familiar voice sounds when the speaker is choosing words in real time rather than retrieving them. I'd ask for a brief recess. He did not look at Celeste. He had not looked at Celeste directly in 3 hearings. He was not looking at her now. But the request, the one Speck had waved off in Chapter 3 without a second's consideration, landed differently this time. Speck removed his glasses. He set them on the bench. He did not wave Grin off. The courtroom held its breath in the particular way that rooms hold breath when something is shifted and no one is certain yet what it is shifted into. Not chaos, not triumph, just the unmistakable sense of a weight transferring from one side of a scale to the other. Celeste closed the folio. The transcript of today's proceeding, she said, combined with Your Honor's published record, is now complete. She walked back to counsel table. She sat. She folded her hands on the table's surface, the folio beside them, and she did not look at Speck again. There was nothing left to look for. Desiree did not write anything. She didn't need to. The court reporter's keys had captured all of it. Every docket number, every date, every title, every line of Speck's own language read back into his own record by the woman he had interrupted 6 times and spoken over twice and turned away from as though she had already left the room. She had not left the room. She had been building the room. What had looked like silence in Chapter 1, those 4 seconds after Speck said, "I think we've heard enough from counsel," when the court reporter's keys had stopped and the room had read Celeste's stillness as defeat, had not been silence at all. It had been patience. She had been letting the transcript catch up, giving the court reporter time to capture every word Speck had spoken before she deployed the citations that would use his own voice against him. The stillness was not the stillness of someone who had run out of things to say. It was the stillness of someone who had already said everything that needed to be said and was simply waiting for the record to confirm it. Speck granted the recess. He did not offer a reason. He did not speak to Grin. He did not look at Celeste. He simply said the word, recess, in the flat tone of a man who needed the room to empty so he could think about what had just been built around him, brick by brick, docket number by docket number, in his own handwriting. Through the glass partition of the hallway, the law clerk from the gallery was already on a phone call, reading from the yellow legal pad. The phone call lasted 4 minutes and 30 seconds. That was how long it took the Appellate Oversight Board's field liaison to confirm what the clerk had been sent to verify, that the transcript matched the complaint, that the conduct described in the sealed envelope was, word for word, what he had witnessed from the back row of the gallery. He had been placed there before the gavel fell. Celeste already knew this. She had known it since the morning of the first hearing, the morning Harlan Speck looked through her as though she were glass. Because the envelope had not been mailed as a reaction to anything Speck did in that courtroom, it had been mailed before he did any of it. The return receipt told the story that needed no argument, delivered at 9:14 in the morning, signed for by the State Bar Judicial Conduct Office intake clerk. The pre-filed complaint inside, 3 docket numbers, Speck's name in the author line of each, the specific procedural protections his own opinions had established, had been sitting in their files for hours before Speck spoke a single word over her. The 9 minutes had not been an ambush, they had been a confirmation. And then there was Foster Grin. The story of Foster Grin did not end in the courtroom. It ended the night before it. He had found the appellate record conflict on his own, a late-night review of Speck's published opinions, cross-referenced against the motion Celeste had filed. Any careful attorney would have found it eventually. Foster Grin found it at 11:47 in the evening, and he made a choice. He chose not to tell Speck, not because he missed the significance, because he understood it perfectly. If Speck's own record contradicted his ruling and Celeste cited it on the record, the damage would fall on Speck, not on Grin. Grin's advantage would survive. His client's procedural gains would hold until the appeal. And in the meantime, he would have watched opposing counsel be dismissed, interrupted, and publicly diminished without lifting a finger to stop it. That was not ignorance. That was arithmetic. The recess Grin had requested, the whispered exchange at the bench that Speck waved off in Chapter 3, had been his belated attempt to warn the judge, not out of conscience, out of self-preservation. By then, Celeste had already read the 3rd docket number aloud. The transcript had already caught up. The warning arrived the way warnings always do when someone waits too long to give them, after the moment that mattered had passed. Speck had waved him off. The case was remanded within 3 weeks of the hearing. The appellate panel's order did not use inflammatory language. It did not need to. It cited the transcript by date, by page number, by speaker. It cited Speck's own authored opinions by docket number, and it noted, in the measured prose that appellate panels use when they mean something precisely, that the conduct of the lower court had materially impaired the orderly presentation of counsel's argument in a manner inconsistent with the standards this court has long maintained. Speck's own standards, his own language, his own record. The State Bar Journal ran the piece 2 months later. Attorneys in the district read it on a Tuesday morning over coffee. Some of them recognized the docket numbers. Some of them recognized the courtroom. All of them recognized the conduct. The piece did not editorialize. It did not need to. A record, once complete, speaks in a register that editorializing can only diminish. Celeste's client was reinstated to her housing. Her name had been on the lease for 22 years before the wrongful eviction. It was on the lease again now. The procedural ruling Speck had issued in chambers, the one that had set all of this in motion, was vacated as part of the remand. The tenant returned to the apartment on a Wednesday. She did not make a statement to anyone. She simply unlocked the door and walked back into her own life. Celeste was back at her desk before the week was out. A new folio tab, a new docket number, a new margin filled with handwriting that no one would read until the moment she needed them to. She did not celebrate. She did not give interviews. When a junior colleague stopped by her office to say something about what had happened, she listened, thanked him, and returned to the page. The folio closed, and there, on the cover, in small gold letters pressed into the leather like a dedication, was a name that had never appeared on a motion caption, never been spoken from a podium, never quoted in a journal article. The client's name, not Celeste's. It had been there the whole time. That is the thing about people who build quietly. They do not build monuments to themselves. They build towards something. And when it is done, when the record is complete and the truth is permanent and the door is unlocked again, they sit back down and begin the next page. Celeste Adaora Nwanne never needed anyone to acknowledge what she had done. The transcript acknowledged it. The docket acknowledged it. The return receipt, dated before the 9 minutes began, acknowledged it. Some people carry their power loudly, and some people carry it in a worn burgundy folio, tabbed and ready, and simply wait for the room to go quiet enough to hear it. If you believe the truth always finds its level, that a record once made cannot be unmade, drop a comment below. Tell us, have you ever watched someone underestimate the wrong person and lived to see the moment it cost them everything? We want to hear it. And if this story found you at the right time, share it with someone who needs to be reminded that composure is not weakness, it is preparation. This channel exists for the people who know that dignity, quietly held, is the most durable thing in any room. If that is you, subscribe, because every story we tell lives in that same world.